Our next case is People versus Butka. Good morning. This is a 15-minute mini oral argument on the application. You have 2 minutes of a free fire zone, which you may waive, and you may reserve time for rebuttal. But we ask that if you do, that you keep track of your own time. Thank you. You can begin when you're ready.
Thank you. Good morning, Madam Chief Justice, and may it please this honorable court. Alona Sharon on behalf of the appellant, Stephen Butka. Stephen Butka is a rehabilitated man whose likelihood of reoffending is extremely low. He does not pose a continuing threat to the community. He is a man who has meaningfully contributed to society and who will continue to do so in the future. He is a man who was facing multiple felony counts, but whose case resolved upon a no contest plea to one felony count, undoubtedly in part because he passed 2 separate polygraphs during the pendency of his criminal case. These are not the statements of a paid advocate, but the findings of a trial court judge who, despite these findings, denied Mr. Butka's motion for expungement solely because of his victim's objections. The judge's ruling was an abuse of discretion, where Mr. Butka's circumstances and behavior warranted setting aside a single felony conviction, and doing so was consistent with the public welfare. The parties have offered various definitions for public welfare, but regardless of which one this honorable court accepts, all dictate the same outcome, a finding that the trial court abused its discretion, because the victim's subjective objection does not meet the definition of public welfare. Public welfare looks to the community as a whole, not the single individual. The definition of public welfare looks to society's well-being in matters of health, safety, order, morality, economics, and politics. The trial court's findings of facts explicitly found that the person Mr. Butka is today does not pose a risk to a society's well-being in any of these areas. And while the expungement statute affords victims the right to notice and to appear and to address the court, it does not afford victims the ultimate veto power on a defendant's request for expungement.
Can the judge consider what the victims say?
Your Honor, I think that is an interesting question. I think the answer is yes, as that information relates to the 2 prongs of the expungement statute. So the expungement statute requires that the judge consider 2 prongs: the defendant's behavior and circumstances from the time of the conviction to the filing of the petition or the motion request, and would granting the expungement be consistent with the public welfare. To the extent that what the victim has to inform the court about is relevant to those 2 prongs, I think that what the victim has to say should be considered by the trial court. And I think what's relevant, Your Honor, is the distinction between, if you look at the language in the expungement statute versus the statute for SOAR removal, or the petition to discontinue registration. Because, right, the expungement statute requires notice to the victim and the right of the victim to address the court at the time of the hearing on the motion to expunge. Whereas to file a motion to stop registration requirements, it not only requires that the victim be given notice and an opportunity to address the court, but there is separate language there that informs the trial court that they must consider the statements of the victim, which is, I think, an important distinction of how the trial court is instructed to consider the victim's statements.
The trial court has very wide discretion in this area. Do you agree with that? The Court of Appeals at times has called it broad, very broad, or very wide discretion.
I think the trial court's decision is reviewed for an abuse of discretion.
But it's more than that, right? No person has an entitlement or a right.
It is a privilege, not a right.
To an expungement.
That's clear from the statute that it is.
So even if they meet all the criteria, they still are not, do not have a right. They can't compel, the trial court can't be compelled to grant the expungement. Would you agree with that?
I agree that it's a privilege and not a right, but I would argue, Justice Viviano, that the statute gives direction to the trial court as to what the prongs are that a defendant has to meet. And if those prongs are met, that the request for expungement should be granted. And failure to grant it is an abuse of discretion.
Well,
I mean, why would they just?
that sounds like an entitlement. Then there's an entitlement. If you meet the criteria, you're entitled to an expungement. Is that your position?
My position is that the legislature sets out 2 prongs that the court is to consider.
It certainly guides the trial court in that way of the things to consider. But the question is, if the defendant comes into court and meets those 2 criteria, is the defendant entitled as a matter of right to an expungement?
I think the statute is clear that it is a privilege and not a right.
Right, so the trial court has very broad discretion.
That is-
Even to decide that someone who meets the statutory criteria still should not receive an expungement.
If there is a valid reason to deny it, I would argue.
Okay, why do you argue, where's that requirement come from?
Well, Your Honor, if that were the case, Your Honor, then I think we wouldn't have cases finding that the trial court denying expungement based on just the character of the crime is an error. I mean, because what would be the argument then if the defendant just can ask for it but isn't guaranteed any right to an expungement?
Okay, so the court said that that's not a valid legal reason
Right,
to
and
deny an expungement. What if the court gave no reason?
that's not a valid legal reason either. There has to be some valid legal reason, and in the instant case for Mr. Butka, there is no valid legal reason. I mean, even if you look back to the statements that the trial court makes back to the first time, and when I say first time, I want to be clear, right? There's this initial time Mr. Butka goes to have his conviction set aside that is not subject.
Why does it matter what the court said at an earlier hearing?
Because when I reference the first time, I'm referencing the first time in roughly 2018 when, and I'll answer your question, Justice Viviano, because the judge made comment, Your Honor, that the only reason he was denying Mr. Butka's first request was that it was only a matter of timing, right? That was his exact words. And that he wasn't making a finding that
So did that create some entitlement to an expungement after that time period expired?
Well, I think number one, he doesn't make a finding that granting the expungement is inconsistent with the public welfare. Never in that record does he make that finding. But what I also think is interesting is that he essentially promises to Mr. Butka that if you stay out of trouble.
I mean, you seem to turn this section 14 around on its head, kind of. It says if the court determines the 2 factors that you indicated that the statute says, the court may enter an order. It doesn't say if the court determines that it has to enter an order or the court has to make adverse findings or enter an order. Aren't we turning the statutory language on its head by requiring the court to make certain findings if it's going to deny an expungement?
I don't think so, Your Honor. I think that the case law, I think, certainly suggests that these findings need to be made. Otherwise, how does a higher court review the trial court's assessment?
I'm not sure there's much room for us to do that, I guess is my point, when the court has this wide of discretion. You know, there's abuse of discretion, and then there's sort of we're at the widest point of the trial court's discretion, which means the appellate court's role is the most limited in those areas. And so that's what I'm trying to determine, what role we have in this area of expungements as the statute is currently drafted. It would be different if there was an entitlement, and then there was a multi-factor test, and then we could assess whether those factors were met or not, or whether we agreed either on the evidence or with the legal conclusions of the trial court. But that's not how this statute is drafted. This statute says if A and B are met, the court can proceed if it wants to, but there's no right. There's no entitlement. It's a matter purely as a matter of grace.
Is that where the principle or the abuse of discretion, right? It has to be a principled outcome to make that decision? Say, I mean, and maybe, would it be an abuse of discretion or a principled outcome to say the factors, the first and second factor are met, but I personally don't like the guy, and therefore I'm not going to do it? I mean, is there no limit to that, or of the trial court exercising discretion? Or is that sort of what we're looking at, is it outside the range of principal outcomes, even assuming the first two conditions are met, that the objection or concern of the victims is a valid consideration or part of the principled outcome determination?
I think so, Your Honor. I think what I'm struggling with, Justice Viviano, is that I think to accept the position that you're taking is that a defendant would never succeed in appealing a denial on a motion to expunge a conviction, but we know that that's just simply not the case. We know that from Rosen, and we know that from a recent case that this court remanded back to the Court of Appeals in Ray Kitts, right?
I sort of think of it like the at-will employment. You know, the employer doesn't have to give any reason for firing somebody, but it can't rely on legally invalid reasons. So to Justice Kavanaugh's point, if somebody was discriminating against a class of people based on their race or gender, for example, and not granting expungements, then I think that you would have a good legal basis for an appeal. And that sort of explains to me the case law in this area that says trial courts can't base it based on the offense, the nature of the offense, because the legislature has made that judgment about which offenses are give a person a right to an expungement and which ones don't. And so I guess to further go on that line, the legislature has also said, hey, before you give someone an expungement, and I was a trial judge, by the way, and I sort of fit in with some of the descriptions of expungements, at least in the treatise I've read, where it was always a good day when somebody was there for an expungement and had done everything right since they were convicted and paid their debt to society. And so those were happy days. But it seems exceedingly strange if we were to interpret this statute, which says you have to give notice to the victim, they have a right to appear, and to make a statement in writing or orally about the expungement, to then say, but the court can't consider those statements, or, to your point, can only consider them if they relate specifically to behavior since the conviction or to the public welfare more generally. We shouldn't credit anything else the victim has to say about the crime and how it's impacted their life.
So, Your Honor, a couple things. It's funny because you mentioned that you can't deny the expungement based on the nature of the crime. I always took that as an indication, looking at the plain language of the statute, that says you look to the conduct and circumstances of the defendant from the time of the conviction forward, right? We're not trying to look back. We're trying to be prospective and looking at who the defendant is now, not necessarily the crimes that he committed. So we're not going to look at the exact crimes that he committed. To me, that's where that case law comes from. It comes from the plain language of the statute. But also, to answer your question, I have never argued that the statements of the victims are wholly irrelevant. They are relevant to the point that they inform on these two prongs, right? Subjective objections from a victim, and thankfully I've never experienced this, they're valid, but to the extent that they don't inform on the defendant's conduct and his circumstances and whether or not the granting of the expungement affects the public welfare, and how we define public is obviously the question that is one of the questions that's before this court, I think is very clear, and I think the Court of Appeals erred in how they defined public. There is simply no definition of public or public welfare that supports or buttresses the definition used by the Court of Appeals. It just simply doesn't exist. And when you think of what the word public means and the definition, Your Honor, of that phrase, using the community as a whole or a country as a whole, one can only think of, right, what is the opposite of public, and that would be private. and that would be the individual or a particular person, group, or class. And that's not what the court is to consider here. I have left almost no time for rebuttal. I'm going to have a seat if the court has no other questions and try and save 45 seconds for rebuttal. Thank you, Your Honors.
Good morning, Madam and Sir Justices of the Supreme Court. I'm Michael Rolla. I'm here on behalf of Plaintiff Appellant. I'm not even going to try and distill down the job Justice Viviano did. He basically states most of the people's argument. I'm not going to repeat my brief. But to follow up on what's been said, I would like to address the court. This court got it right, I would submit, back when you made the decision in People versus Peters, 449 Mich, 515, 537 Northwest 2nd, 160, 1995 case, a long time ago, where this court recognized that changes had to be done, not only to our Constitution, but also then you had recognized the Crime Victims' Rights Act, specifically recognizing that following those protections for victims were consistent with public welfare. To quote the court, it indicated that affirming the rights of victims of crimes being present at, allocating, and having their statements taken into consideration by trial courts at a hearing on a defendant's motion to set aside a prior conviction is appropriate. It is consistent with public welfare purposes of protecting all past, present, and most importantly, in this case, future crime victims and their participation in the criminal justice system when they were, are, or will be the victim. The people would submit, plaintiff appellee would submit, that to do otherwise would in fact be inconsistent with public welfare and would be contrary to the specific provisions of the Crime Victims' Rights Act. More importantly, or perhaps additionally important, it's a situation where this court, as I indicated in our brief, all the places where the Crime Victims' Rights Act specifically recognizes those rights. And for the argument to be that, well, there's been no decision as to defining public welfare. Actually, there have been several decisions as set forth in my brief, one of which was the ACLU decision, which defined then public welfare as well.
Counsel, I wasn't so much trying to articulate the position of one of the parties to this case as I was looking at it from the vantage point of a trial court judge, which I spent some time in my career serving as, and also looking at it from the perspective of the appellate courts who have had to grapple with this language, and it is a little bit difficult, but there's been some unpublished decisions. One is the Giles case that says the setting aside of a conviction is at the trial court's discretion, even if the court is presented with evidence showing the circumstances warrant setting aside the conviction. That was that Court of Appeals panel's conclusion after reviewing the language that I mentioned to counsel, subsection 13 of the prior act. I think it's moved one subsection in the new act. Another case, this Amant's case from the Court of Appeals, talks about that there are situations where there may be more than one reasonable and principled outcome, and even if setting aside defendant's conviction was one of the principled outcomes, denial is another principled outcome. The court lamented the fact that there's not clear standards in this area for trial courts and advocates and applicants for expungement, but that court recognized that absent legislative action, the courts are left to prudently exercise their broad discretion. And so just to sort of bring it to some sort of a question, this gentleman, maybe if he appeared in my court, would have his expungement, even if the victims opposed it. Trial courts can do that, but sometimes they're impacted by what the victim has to say, even if the victim's statement is, which it often is and almost always is extremely personal to the victim and how the crime has impacted that individual. What's wrong with that system, and does it deviate from what the legislature intended?
In fact, I don't think it does, because the legislature, in drafting the statute for setting aside expungement, specifically used the term may. which means it has to be discretionary. That's been found by our appellate courts on numerous decisions. I also think, quite frankly, that it's odd that the defendant appellant is basically arguing you have to only consider what applies to the defendant, one person, in determining what's good for the public welfare, what the defendant appellant has done since the conviction. And again, I think as reflected in the trial court record, the original trial court did the exact opposite. They specifically considered statements from supporters of the defendant, letters from supporters of the defendant, statements from the victims themselves, statements from family members of the victims themselves, in making the determination that hearing all of that evidence, and again, there are other cases that held to the contrary, but those cases generally dealt with, well, they didn't get a statement from the victim, or they didn't allow the defendant to talk. That's not our case. Our case, the trial court did exactly what the legislature is telling it, I respectfully submit, to do, because they took in all of the information and then made a decision whether or not it was consistent with public welfare. To do otherwise, I would respectfully submit, would be to take a court, an appellate court, and put it into a position of a super legislature. Oh, you said the trial court has grand discretion. Oh, you've said that even if all of these requirements are met, if the trial court determines within its discretion that it's not consistent with public welfare, oh, we're going to do otherwise? No, then that would be changing the statute. As you indicated earlier, there can sometimes be two decisions which fall within the standard of reasonable parameters. It's a situation where to grant it under the circumstances would not have been an abuse of discretion. A decision not to grant the application, therefore, also has to be not an abuse of discretion, consistent with the legislature.
Are you done? How do you harmonize the court's rationale in granting relief in 2019 by way of the SORA removal and allowing reapplication in 18 months, and then in 2021, denial of the application, thereby requiring to wait another 3 years to apply? I mean, when we're trying to decide, is there some discretion here? We're looking at the state of the mind in 19, 21. What's the difference other than the fact he comes to court in 21 without counsel? And should that matter?
To answer the court as I understand the factual circumstances, and having been present through all of this, I'm relatively familiar with it. In fact, as indicated by appellant's counsel, the court on the record indicated, well, look, I'm allowing you to be released from SORA at this point in time. And if you come back in about 3 years, if nothing else has changed, and I'm paraphrasing the court, but I'm pretty close to the language, I don't see a reason why then I wouldn't grant your application for setting it aside. Now, that was handled, that original hearing was handled by one of my predecessors. When I saw the transcript on that, as indicated in the later hearings transcript, I brought that to the court's attention because it bothered the people that, wait a second, with all due respect, Your Honor, you can't say you've made a decision now 3 years ago and you're going to be bound up by that decision. Because if you do so, you may have to recuse yourself because then you're no longer deciding this with neutrality towards both sides. Which is why I think then the court went through a very extensive reason as to why, considering the victims, considering the impact of them, and I'm not going to repeat the actual factual horrific nature of the crimes, not what he was allowed to plead to, which was a 2-year offense when actually he was charged with 15-year criminal sexual assault felonies originally. The court went through all of that and then found that because the victims are still being impacted by this. And again, I say to the section in my brief where the defendant appellant was given the direct opportunity at that hearing to effectively convince the court that it was in the best public interest to grant it, when he was asked the question about whether or not he can actually at least agree to understand that although he can put this behind him, the victims live on with it and they can't put it behind them.
But
And
counsel,
he
wouldn't
refused
that
to
be
do so.
true in like every crime where there's a victim? I mean, so are we now under, we have this new expungement statute, which is broader than what we've had in the past. Is it true now that every case where there's an expungement, a victim can show up and say, I'm still in pain, which I do not want to minimize that, of course, I understand that. Is that now every judge in the state can just deny the expungement?
I don't agree with that assessment. I would respectfully say that if they're all fact-driven. This happened to be factually driven on a number of circumstances. The facts that the victims indicated, it's still affecting their livelihood, their marriages, their relations with their children. In this case,
But I would say that's probably true of a lot of crime.
and I would agree. And also in a lot of cases, the victims say, look, I have no problem having it set aside. But in this particular case, in addition to what the victim said, the words came out of the defendant's own mouth. No, I think I'm basically saying I'm entitled to it. If they can't put it behind them, then that's their fault.
Is that really
on
what he
them.
said?
Pardon me?
Is that
Well,
exactly what he said?
Exactly, and again,
I don't, that doesn't matter. So what I do want to ask is the definition of public welfare.
Sure.
You've put forward several definitions. It seems to me all definitions seem to at least mention the public at large or the community. And I'm having a hard time figuring out how individuals fit into that definition. I understand they're part of the broader community, of course. But all definitions seem to talk about something bigger.
well, and I agree with that they do, but they also indicate that in coming to that determination of for the public at large, things that serve the public's welfare at large. And in this case, protecting the rights not only of victims, not just present, but future victims, serves that greater public at large.
Okay, thank you.
So is it, I just want to be clear, are you taking the position that the trial court exercising his discretion in this case to consider and what value he places on the victim's position informs the question of what the statutory term public welfare means? That he has discretion in a particular case to decide whether it's public welfare or not? That seems, I mean, it can still be a discretionary decision, right? A is met, B is met. I don't think, and maybe, correct me if I'm wrong, I don't think you're saying that the trial court's discretion, it's in the trial court's discretion to decide what the public welfare is in this case?
No, I'm not saying that at all.
It's a legal term, correct, in the
Correct,
statute
yes.
that is a matter of law to decide?
Correct. And I think what the trial court did was found that, in coming to its decision, that satisfying and protecting the rights of victims as those rights are set forth under the Crime Victims' Rights Act and as recognized under our Michigan Constitution, Article 1, Section 24, protecting those rights serves the public welfare. So that's why the court said they could take into consideration the feelings of the victims. They're not defining, I don't believe the trial court defined public welfare by what the victims want. I think that would be incorrect because it's a legal term. I don't disagree with that. But what I think the trial court did is, contrary to the position of the defendant appellant, that said, no, you can't consider any of that. You only have to consider what I, the defendant, have done since this occurred, and nothing else should take into consideration. I think that's wrong.
I don't think that's fair to characterize what they're saying. They're saying for the first prong of the circumstance of the offender and the conduct that occurred post-conviction. And then the second factor in the statute is that it be consistent with the public welfare.
Correct.
So it wasn't just the factors relating to the individual defendant, right? It had to do with expungement, it had to do with the public in general.
But that's why this case is effectively facts-driven to some degree. Again, as I argued to the trial court, the decision that they're making on this isn't just impacting just these victims. It's impacting all future victims in this regard.
Can you give me an example of when you think it would be an abuse of discretion to deny the expungement?
I would say, as an example, it's a situation where if this court were to grant the position of the defense, which I still respectfully submit is an entitlement position, is what they're really asking. They're saying it doesn't matter how it affects victims at all. Because I met these conditions, I should get this set aside. That's exactly opposite to the rights specifically recognized in Peters and as set forth by the Crime
So
Victims' Rights Act.
let's say I agree with you that the first two factors are met. It meets the public welfare and the conditions of the offender. But it's still a matter of discretion of the trial court, even though the statutory conditions or statutory terms or guidance or whatever we want to call it have been met. What would be an abuse of discretion under
Well,
those circumstances?
Sure. For example, as our appellate courts have already decided, the judge was so focused on the crime that they felt it was so abhorrent, under no circumstances, regardless of what the defendant did, the court denied the application, and our appellate courts have found that that is an abuse of discretion. Or, to use the other example, deciding it because they didn't like that particular person, or maybe the group that particular person belonged to.
Is
That'd
it
be
your
like a civil
position
rights
that
violation.
that the
That'd be an
victims-
abuse of discretion.
Is it your position that the victim's perspective or opinion can never, that it's never an abuse of discretion if the victim objects to it?
No, exactly. And again, that's what's unique about this particular, I would submit is unique about this case. It would not have been an abuse of discretion for the trial court to grant the application. It's not an abuse of discretion of the trial court to have granted it.
Okay.
Thank you, and I reserve any time, if I have any left, for rebuttal, unless there are other questions of the other court. Thank you. Thank you.
I would like to very quickly address a few points. First, Justice Zara, you asked how can you reconcile the decision to allow him to end registration but deny expungement. I don't think you can. I think it's impossible, and I think that that must lead this court to find that it was an abuse of discretion to deny the expungement, because the same findings, and if anything, the standard was higher to end the SORA registration because he was required to take into consideration under that statute the statements of the victim. So the fact that he granted one and denied the other was an abuse of discretion. I also just want to say that the statements of Mr. Butka at the second motion hearing, it is clear from the record that his statements were in no way taken into consideration by Judge Hunter in denying the motion for expungement. My time is up, so having no other questions from the court, I would ask that the court reverse the opinion of the Court of Appeals and remand it back to the trial court. Thank you.
Thank you both. The case will be submitted.